Okay, good evening, everybody. It is Wednesday. It's a little bit after 8:30 p.m. And if it's Wednesday, then I'm live. Wednesday, Wealth Wednesday, Wisdom Wednesday, um, whatever kind of Wednesday you want to call it. I know that it's my favorite day and it's because it's the day that I was born. All right, so today, I just wanted to go and talk about a topic that I have had at least three people talk to me about, right? When things happen in your life, sometimes it causes you to think. And so tonight, I thought it's a good idea to talk about that since I've been having some conversations with other people. So what are we talking about? We are talking about estate planning, right? And for most of us, when we hear the word estate, we are thinking of, some huge sprawling estates with large houses and lots of land and cars, Lamborghinis, Maseratis, a whole bunch of um, assets, lots of homes. And we think to ourselves, that doesn't apply to me, so I do not need an estate plan. Let us put some of those to bed because it's a myth that you do not need an estate plan. You're 18 or older, you need an estate plan. Everyone needs an estate plan, right? So let's talk a little bit about um, what is your estate, right? Your estate is basically everything that you own, whether it's money, whether it's property, any personal belongings, checking accounts, savings accounts, cryptocurrency, your 401k, stock trading accounts. Any of these things, anything that you own, if you died, becomes a part of your estate. And before you say, well, I don't have any of those things, so, why would I need an estate plan? You still do need an estate plan, right? As long as you are an adult, you need an estate plan. So let's talk a little bit about what's included in an estate plan. An estate plan is basically a set of documents, right? A set of documents that says what will happen to you and your stuff when you are gone. So let's say we have a young adult, 18, 19, 20. Once you're 18, you're considered an adult. And that's the time to begin your estate plan. So, for those people who are listening to me and you have young adult children, you want to talk to them about this. The very first thing you want to make sure that you have for them is a healthcare directive, and that either you or someone responsible, whether it's another sibling of theirs, an older sibling or something, becomes a healthcare agent for them that is able to make decisions or tell or communicate the decisions that they have made if they are unable to speak. So if you got into a car accident or something and you're now in the hospital, your adult child did, you cannot go up there and try to find out what's going on. They could tell you they cannot give you any information, even though you are the parent. So that adult child, if that's an oxymoron, that 18-year-old needs at least in his estate plan some healthcare directive and power of attorney that will enable you to handle that adult child's affairs. Right? So, at least those two documents should begin your estate plan. And it's not a one and done. So, as things happen, you're going to expand that estate plan so that it can take care of things for you. Right? So, as I said, an estate plan, it just tells what's going to happen to your assets, to the things that you own when you are gone. And therefore, everyone needs an estate plan. By the time we're age 30, most of us have, at least some checking accounts or savings account. We we have some things that we may own a car, we may own some jewelry and things like that. So we need an estate plan. Does everybody, so an estate plan, and most of the times when people think of estate plan, they just think of just a trust. So that's, everybody doesn't need a trust, right? If you do not own any property, real estate property, a home that you live in, a will can definitely suffice, right? Um, and then there's some additional things that you can do to protect your other assets. For instance, your bank accounts and your 401ks and your well, let's go back, not bank accounts, not 401ks yet, but just your bank accounts, your checking account, your savings account, any kind of maybe trading account that you have. You can actually put on those what is called a payable on debt beneficiary. You can put a beneficiary on there that's payable on debt. You might see it says POD. That is part of the big huge plan. Now, if you have a lot of money in your bank account and you don't want that money to be payable out to, maybe let's say your 21-year-old child, you don't want all that money to put out to be given to that person at one time, then you absolutely need something else that will say where that money goes. Number one, if there's no instruction on there, there's no payable on that beneficiary, your bank accounts immediately becomes a part of the probate process. And your child, no matter how much you love them, will not be able to access that. So in that case, you will want to make those accounts a part of your trust and then say how you would like that money distributed to those children, adult children. All right. You definitely do not want to just write a will if you have um, an extensive amount of money in a savings account or bank account, which, by the way, we all saw over the weekend, um, at least two banks failing, right? Well, one definitely failed over the weekend, and the second one was in the middle of failing, and they came in and took it over. And I think there might have been a third. I'm not sure about that. But when you have huge amounts of money in a bank, especially a business owner, entrepreneur, you have lots of money in a bank, in excess of $250,000, it's only FDIC insurance only covers up to $250,000. So anything above that, you will not get back. So for instance, number one, you don't want to keep 250,000 more than $250,000 in any one account or in any one bank because you're subject to lose it if the bank fails, right? Um, and you guys have listened to me lots and lots of times before where I don't even want you to keep $10,000 in an account, right? Yeah, you can have a couple of hundred here and there, a couple, maybe a couple of thousand that can cover immediate emergency, if you need immediate emergency access. But even in the vehicles that I show you or talk about, you're able to get access to your money pretty quickly and still have that money make money for you in the bank. So that was kind of a stray away from about keeping large amounts of money in the bank. But if you did have a large amount of money in the bank, you might not want to do just a payable on death because if you did that, the money would be paid to the beneficiary right away. So if you wanted it to be paid out over a period of time, or you wanted to be paid out when something happens, for instance, when the child graduates from college, that's when you want him to get $50,000 or $25,000. And then maybe when he gets married, you want to give some more. However, whatever it is that you want to do, those things have to be addressed in a trust. All right. So we talked about the fact that you need in the estate planning, some of the documents. There are lots of different documents that can be a part of that estate plan, but some of the essential ones are, of course, your trust if that is needed, right? And in the trust you would put bank accounts that had substantial amounts of money. If it didn't, you could just do the payable on that. In the trust, you will also put um, your 401k, if you wanted it to be able to be distributed a certain way, or sometimes when you actually sign up, you can tell how you want that money to be distributed. But a lot of times the money has to be taken and used by a certain time because there are tax implications and all sorts of different things. But in the trust, you definitely want to have any real estate that you have, your your personal residence needs to go into that trust. It is not that difficult to do it. Most people are going to tell you that you do need an attorney to create a trust for you. You should get an attorney. You should seek the advice of an attorney to create a trust, especially if you have a substantial amount of assets. But if money is something that's tight for you, but you want to protect what you have, do not let the fact that you cannot afford an attorney's expensive prices prevent you from getting a trust. It's something that you can do on your own. You can seek the help from, there's lots of be very careful before you trust someone, but there's lots of things that are available for you to get your trust done. Or you can seek some paralegals or people with knowledge, right? If you have already created yours and you have a friend or a cousin or someone that needs to get theirs done, you can help them, right? It's on that person to make sure they review those documents and to make sure that they make them valid. Because just creating a trust and writing it down doesn't do anything. That it might as well not do anything, right? You have to create the trust. You have to get it notarized. You have to have witnesses, depending on the state. Some states require more than one witness that will be able to um, notarize that and make it valid. If you once the trust is created, now you have to fund that trust. So it's not about just getting the paper created and notarized. If nothing is put into the trust, it's like opening huge um a huge uh bank vault, but not putting your stuff in there and locking the door, right? So you have to put the stuff in there for it to be protected in there, right? So you have your you would then make sure that your house was transferred and titled and over to the trust. It's a meticulous process that needs to be done, but that can be done, right? So you have your trust. You will then also have what is called a pour over will. That you might say, well, why do I need a will if I have a trust? Well, there's some things that may not go into your trust, right? Some things that do not have to get titled, like your cars and your homes and real estate property, land, things like that can go into the trust. Bank accounts, savings accounts, mutual accounts, all these things can go into your trust. But you might have some jewelry that you intended to put in there, you didn't. You might have some fine china, things like that you didn't. Anything else, you can cover it in the will. Things that are most likely not going to go to probate, people are typically not going to contest that. But anything that can be contestable, you want in the trust, and then you can make your wishes known in that pour over will. All right. So that's a second another document that be in there. Your financial powers of attorney and your medical powers of attorney, those are also part. You might hear the term durable power of attorney that allows someone to act on your behalf if you are not able to act. So that would be another document that would be in your estate plan, in your documents. Um, Another one would be the certification of your trust. Because once the trust is created, you just do not want to take the entire trust and hand it over to a third party. And a lot of times you'll be needing to make sure certified that the trust does exist so that you can retitle things. And so now you will have that document that certifies that that trust does exist, right? Some other things that would be in that trust, excuse me, are I have made some quick notes of some other documents that would be in that trust. Um, okay, so, oh, your healthcare directive would also be in there. Any kind of final disposition, how you want to be, whether you want to be buried, whether you want to be cremated, final handling and disposition of your body. That would be another document that is included in there. So all in all, there's between 10 and 12, maybe 14 documents that can be a part of a trust. So it's actually important for you to talk to someone who kind of knows, or do your research um, on what is needed, what are all the things that needs to be in that trust, because you'd hate to get a vault, put some things in there, and then forget some outside of it. So you want to make sure that they're all in there, right? So I said before, everyone needs a trust. So in order to drive that home, let's talk about some of the myths, right? I'm too young, so I don't need it, right? And I already said most of us by the time we're 30, we have a bank account, we have a retirement account, we have debts, we have personal property. All of these things has to be handled when one passes away. So what happens to all this stuff? So I know that it's frightening to think about your own debt, um, but your own death, not debt, death, but your own death. But this is some things that we need to do so that it's easier on our loved ones if we create a plan before we go, right? Um, Second thing that married couples will say, I don't need to do anything. My wife or my spouse, my husband, is going to get everything when I'm gone. So even though that could be true, an estate plan prevents people from contesting ownership of anything that has been left to your spouse, and then having it potentially dragged through the courts. And it's an expensive process to go through that probate process, right? So things could get messy if you don't have a written plan, even if you think everything should go to your husband or wife. Another myth would be, my family knows what to do. Well, y'all, death changes people. Serious illness changes people. So even though if you might think that everybody knows what to do, that's the time when people are arguing amongst each other, especially if there's a sizable assets that needs to be distributed. There's fights among people, and sometimes it ends up in the courts, lawsuits, and all sorts of things. I think a quick example would be, you have three adult children, you have one home, and you decide, I'm just going to leave it equally to split to all three of them. And maybe two of them decide, you know what, we can keep the home here, we can use it as a vacation home. But the third one decides, nope, I just want it sold and I want mine, right? And now the whole family is splitting apart, right? And it's just better to be able to get that taken care of. It's also not a one and done, right? So for instance, you have like, when I talk about your young adults that start creating their estate plan, and they may just have their healthcare directive in there and their financial power of attorney in there, and they may have a will. The problem is that when something happens, life changes, they get married, or some other big change that needs to be reviewed again. You do not want to be married, made a plan, got divorced, and then if you die, you never made any changes, and now everything goes to your ex. You probably wouldn't want. You probably wouldn't want that. Ex will probably be happy, but you probably wouldn't want that to happen, right? And then just understanding what happens with your estate after you die. If you just basically understand the estate planning process, then you would know that everything that you own at the time of your death becomes a part of your estate. And if you don't have a will, or if that will is invalid, then the state decides that you've died intestate. And once they decide that you've died intestate, then the courts makes the decision of what's going to happen, of who's going to inherit your assets. And it might not be in line with what you want to do. Of course, probate, then everything goes to probate. And probate means that they have to verify that your will is legal. Even if you leave a will goes through probate. And if you don't leave a will, it definitely goes through probate. When you leave a will, the will would be a guide for how the courts would use your will as a guide once they verified that it was legal. And then they would try to carry out your wishes as you stated, barring there are not a lot of people contesting that will. All right. Um, Probate is an expensive and a tedious and a long process, and you don't want to put your family through that. All right. I'm not going to get into some other things about taxes and things like that. Most of us will not have to worry about federal taxes unless I think in 2023 the amount on taxes on the estate was it had to be over 12 million or something like that. $12.92 million. If it's over that, then you would pay federal taxes. There's some states that also require that you pay taxes. That's something that you can look up. There's like 12 states in the District of Columbia that you may have to pay taxes on your estate if it's worth at least $1 million when you die. So for most of us, that may not apply to us. If you keep talking to me, it will, because you guys know that I want us Black people to make sure that we are passing on generational wealth. We're passing on money, which means we definitely need to have trust and have trust set up and things like that, because we are passing on real money, millions and millions of dollars. But of course, if we pass it on in our trust, your life insurance policies could go into your trust, and then you can rule from the grave of how that money is passed out. All right. So that's just a little bit that I wanted to talk about estate plans today. I'm Carmen Bernard. If you popped in here in the middle of me talking, or you got this after it was recorded, type hashtag replay. Make sure that you ask any questions. I'll have more information coming out about just this very same topic. But reach out if you have any questions. And remember, I am always getting people to join me in what I do as we continue to educate our community in these financial matters. You can reach me at carmen@bigfacts.com, carmen10k.com. You can inbox me on Facebook, Instagram, on my business page, anywhere. But if you found this interesting, please share the video. If this is not you, you don't need it, share it. Someone else needs it. I want to say thank you so much for spending a few minutes with me. And I will catch you next week, same place, same time. Thanks. Peace.